Hi, this is Shaparali for video 4 our series Immigration Attorney Answers, video answers. So now today we're going to talk, of course, anything that I'm going to tell you is for educational purposes only. You should not act or refrain to act solely on the information provided. I'm going to talk about something very interesting. We have a very interesting question on our forum, splawforum.com, splawforum.com, and the question pertains to basically AC21. And our client, not client, it's the person who posted the video on this, and that person basically asked a question about job change while adjustment of status is pending, which is the I-140 and the I-45. As you know, in order for you to proceed usually on the labor to get a green card to employment, oftentimes you have to go through what we call a labor certification, which is the first step. Then you move, of course, to the I-140 and the I-45, depending on your category, which is EB1, EB2, or EB3. I'm not going to go into details into that. You can read about them on our website, piralilaw.com. But the question is very specific to AC21, which is the American 21st Century Act, which pretty much can be summed up in that famous memo of May 2005, if I'm not mistaken. And the question says, is job change with pending adjustment of status? And you can read that question on the link below. And this is what the question was asking. What are the implications? And this was asked by one of our anonymous people who ask questions on our forum. By the way, you can be anonymous and just create a fake name. The name he uses is BMW 2012. And he asked that question, or she asked that question. What are the implications of changing a job in the following circumstances? 1. EAD was approved valid till 03/12/2013. Adjustment of status pending approval. H-1B extension filed on 06/07/2012. Expiry date is September 30th, 2012. My current employer is not willing to release the copies of the approved I-140 and PERM. Please advise. Well, very, very interesting situation. For one, it seems that this person, as per date of today, which is in December now, December 2012, 180 days has already passed since the I-45 has been filed, which is the adjustment of status. That means that person can move to a same or similar position. And that goes into really the AC21 issue. People get confused. AC21 is not an H-1B transfer. It's not have to be really be transferred. You can work on your work permit. But the AC21 is how you react, how you behave. So basically, if you're behaving you're moving to a same or similar position, and 180 days have passed, you are already doing the act of AC21. But we highly recommend that you send a letter, even if the law doesn't request that letter. The reason we are saying that is that we are seeing many cases where USCIS are making mistakes or getting confused how to prove that this person moved to a same or similar position. This is where it's very good to contact an attorney to do that letter. We have done hundreds probably of AC21. I have not counted them, but approximately. And we have been very, very successful. So contact an attorney who knows how to do an AC21 for one. So that means basically now, once you move, I repeat that, once the I-140 has been approved, 180 days has passed, and the I-45 has been filed after 180 days has passed after the I-45, that means the adjustment of status has been filed. Technically, the employer cannot revoke the I-140. It doesn't belong to them anymore. The only way it can be revoked usually is under what we call the fraud, if there was fraud on the I-140. So beware of that and don't panic, but there are mistakes. I've encountered a lot of mistakes lately where AC21 letter was not filed, or it was done too late, and the client basically, people have been moving around different jobs, and they have not kind of kept a good record of it. So be very, very careful. Whenever you're moving to a job, contact an attorney who's familiar with the AC21, American 21st Century Act. In the case at hand, the question was, how do I get the I-140 and the I-40 and the labor certification? One way to do that is to a FOIA with the labor certification with the Department of Labor. FOIA's Freedom of Information Act is typically free, and we have a link actually on this forum, on the forum SP Law forum, how to do that. So check it out and try to do it. As for the I-140, if you have the number, that should be good enough, and if you have the labor certification, we can get the job description. Contact us for more details or for a consultation at 510-742-5887. And post your question on our forum, by the way. I'll be glad to select some and answer them through a video answer, which is a new thing that we are starting now. So thank you very much, ladies and gentlemen. I will be glad to answer more questions for you if you post them there. And again, whatever I'm telling you today is for educational purposes only. You should not act or refrain to act solely on the information provided. Contact an attorney, call our office if you have questions, 510-742-5887. Until the next video, goodbye.